What's up, everybody? Welcome into something we knew was coming, and it's finally here. Alec Baldwin has filed a lawsuit against the prosecutors in his case, alleging so many different things. And it's really interesting to see how someone who has won their criminal case, getting all those charges dismissed, not having to go to jail, coming out looking like a winner at the end of the criminal process, but how different that is than a civil case against prosecutors. We'll talk about how difficult it is to win a case like this and whether or not we think Alec Baldwin has enough to cross that threshold and clear that bar that is so high for suing prosecutors for filing charges and prosecuting you for a crime that you eventually win, even if some may call it a technicality. So let's get into it. So we've got the lawsuit up here, and like many of the lawsuits we've been reading lately, it is 75 pages long. So instead of reading all 75 pages, especially because the way these lawyers, which I thought was interesting, Spyro is not listed on this, but Nicholas was, or Niklas, however you say his name, I don't remember. Good Greek boy though. So what we're going to do is we're going to summarize parts of it. We're going to read parts of it, and then we're going to read through. You can see the 6 causes of actions that Baldwin's team brought against these prosecutors. And we're going to read through all of those. And how I like to write up complaints, which is how these lawyers did it, is you fuse these facts into the causes of action so that when you're reading what the causes of action are and you're trying to determine how the lawyers are going to, or how the plaintiff is going to prove it, those facts fused in there can give you the analysis as we go through. So we're going to focus fully on all of the causes of action, which is like the last 20 pages of the complaint. But we're going to read some chunks and summarize some chunks. And we're going to start out with the fact that Baldwin is the plaintiff, and the defendants are Morrissey, Altweiss, Reeb, Macias, the First Judicial District Attorney's Office, Hancock, Popple, Brandel, Santa Fe County Board of Commissioners. So all sorts of people that work for the prosecution team, the investigative team, some law enforcement officers that were involved in what Baldwin is calling basically malicious prosecution, violating his rights. And we're going to go through the different ways, and you see the 6 causes of action there. We're going to look at them in detail, look at the elements, look at the definitions, and look at what facts Baldwin's team believes proves these causes of action. First off, we're going to remember this is civil court, so just basically a preponderance of the evidence, more than 50% to win, not beyond a reasonable doubt, a much lower level. And Baldwin is on the side of the plaintiff, and the people that are usually the prosecution side of the case are now the defendants. So he gives an introduction. We go through the background of Rust. If you guys have been following this case at all, you know about it. Movie being filmed in New Mexico. Live ammunition somehow gets on set. The firearm in Baldwin's hand goes off and ends the life of a producer and hits a director. The producer dies. There were civil lawsuits. Baldwin and a lot of the production team settled a lot of the civil lawsuits. There are still, I think, some pending civil lawsuits. But generally speaking, it seemed like it might be over with the victim and her family because they got rights to the film, money, etc. But that's not what happened. Criminal charges came for the armorer, Hannah Gutierrez Reed, and she was convicted. Criminal charges came for, I guess, David Hulls, the first AD, pled guilty to a misdemeanor, and then Baldwin also had criminal charges, and that case went to trial, and he lost. At first, the charges were brought and then dropped, then brought again, went to trial, and they lost, meaning the prosecution. Baldwin won because all the charges got dismissed. We'll get into those factors here, but generally speaking, this is all something that happened on a movie set, and then they go through the different parties, who they are. I guess we can read through this kind of quick. Morrissey was a special prosecutor who's also a defense attorney. Carmack Altweiss is the DA for the First Judicial District of New Mexico. Reeb is a former DA, 9th Judicial District of the state of New Mexico, a member of New Mexico House of Representatives, and a resident of the state of New Mexico. She was also appointed as special prosecutor. Jennifer Paget Macias is ADA for the First Judicial District. Alexandria Hancock, law enforcement officer, if you remember her. She was the red-haired officer who we're going to talk about some of her testimony throughout. Popple was the crime scene person. Brian Brandel was a law enforcement officer and supervisor. The first DA, Judicial District Attorney's Office as a whole, the entity, and then the Santa Fe County Board of County Commissioners. Okay, so those are all of the defendants. They get into the Rust production. They discuss the facts, and like any civil complaint, These are the facts through Alec Baldwin's eyes and how he sees the facts. They do state some facts in this complaint as true, in that because he did not get convicted criminally, that means these facts must be true. And as any case, in a civil complaint, if we're talking about a motion to dismiss, the judge will look at these facts as true. But these are facts that the plaintiff is going to have to prove throughout the litigation as to them being true. Just because, this is an important thing to think, just because Alec Baldwin did not get convicted in the criminal case does not mean that the state broke the law in bringing it. He still has to prove that with these elements that they overstepped. They targeted him. They wanted the fame. They hid things. They buried things, and they just wanted to go after him and violated all his rights. That's still what he has to prove. So let's keep that in mind as we discuss some of the facts in the case. We're going to jump to page 14 here for the first chunk we're going to read. All right. So they talk about the investigation. They talk about the incident happening and how obviously law enforcement was involved. Prosecutors are involved and the investigation begins. And as prosecutors became more involved in the case, their focus shifted from identifying the source of the live ammunition. They instead fixated on Baldwin. And we start to see how they want the big fish, right? That's what a lot of this is about. This shift occurred even as more evidence emerged that Seth Kenney, a third-party ammo supplier, may have been the source of the live round. And it continued despite the consistent finding throughout the investigation that it is not an actor's job to check for live rounds inside a prop gun that those responsible for gun safety have cleared for use. So a lot of these again, statements here, like paragraph 77, are going to be things Baldwin still has to prove. It's not res judicata. What res judicata is something that's already been litigated and decided. And sometimes you have that. For instance, if he would have been convicted, the jury has already decided that he committed a crime. He did something wrong. But because that hasn't happened, and if he was not guilty, sometimes we don't know why, right? It doesn't mean he did one thing or didn't do another. It could be jury nullification. It could be the mens rea issue. It could be the live ammunition on set that they found that he didn't have a duty. It could find that they don't think he did pull the trigger, and they believed in their mind as the jury that he would have had to pull the trigger in order to be convicted. All these different reasons and things could have happened as to why they find guilt or not guilty. But when you have a situation like this where the judge threw it out, we don't really have a lot that has already been decided. So we're going to have a lot of the same arguments here. Whose duty is it? Who was the real person at fault for this death? Was it whoever brought live ammunition on set? Was it whoever did check the gun or should have checked the gun? Is it the person holding the gun in their hand? Is it the person pointing the gun? Is it the person pulling the trigger? Who is at fault? Is it even Helena Hutchins, the victim's fault, because she told Alec Baldwin where to point the gun, right? Those are all still questions that are going to be litigated that we still have to decide here, which is why you're going to see throughout that this is still a long shot and something Alec Baldwin's team is going to have to prove. Now, what I will say is there are a lot of horrible, deplorable things that the prosecutors did in this case, especially the first team. And it is so bad that it wouldn't surprise me if they paid Alec Baldwin some money. Frankly, they botched this so bad that if this was not a government agency, they'd be paying people money for the negligent and horrible way they handled it. But does it rise to the level of some of these causes of action? Driven by the prosecutor's agenda, SFSO began to ignore critical evidence as to the live ammunition, how the live ammunition ended up on set. For example, SFSO waited 6 days before executing a search warrant on the prop truck, the vehicle where firearms and ammunition had been stored. At Gutierrez Reed trial, Detective Hancock testified that this delay occurred because SFSO didn't have information until later that this prop truck had been involved in the props department and that we would potentially need to be looking for that evidence, which is why we didn't conduct the search until a few days later. That testimony was false. Within hours of the incident, Detective Hancock knew that the importance of the prop truck when Gutierrez Reed told her that the guns, the dummies, and everything are kept on the prop truck. In fact, the search warrant states that Detective Hancock conducted an interview with Hannah Gutierrez, who advised on the day of the incident that firearms were secured inside a safe on a prop truck and that ammo was kept inside the prop truck. Detective Hancock lied about her knowledge of the prop truck to cover up the real reason SFSO waited 6 days to execute the search warrant. Prosecutors were not interested in pursuing the source of the lethal rounds because if it turned out that the round came from outside the source, such as Kenney, who Baldwin has pointed the finger at throughout, it would be difficult to blame Baldwin. This was confirmed by two sets of prosecutors, both of whom sought to hold Baldwin criminally responsible for failing to supervise crew members based on his role as a producer. So what I'll say is they're going to call a bunch of things lies. I just realized that my light isn't on here. They're going to call a bunch of things lies throughout this case, and that this was false testimony. And I think we have to remember that each side will be able to explain, oh, here's what I meant. I didn't mean this. I meant that. And yes, it was important, but the delay was because we were first interviewing people and we couldn't do both at the same time. They're going to come up with all sorts of reasons. And these types of things I think are going to be difficult to stack up as the major evidence of malicious prosecution, but there's a lot more coming later. They continue talking about the delays and things that were some contradictions in the testimony. Again, we're going to get to more of it later. Another part that they talk about is the state destroyed the actual firearm in question in their testing, which was destructive testing. Now, this was brought before the jury in Gutierrez Reed's trial a little bit. It was going to be a big part of the Alec Baldwin case. Would this have been enough for the jury to be like, it wasn't fair, Baldwin's team didn't get to test it enough? Or because the way the experts explained it is, this is the only way for them to know destructive testing, and they got their answer, and the answer was the gun was fine. So again, this is something that, legally speaking, was not going to be enough to throw out the case, may or may not have won over the jury. But at the end of the day, Baldwin is using it as yet another piece that he's stacking on top. And again, he's stacking, pebbles up on a scale, as I think Mark Betterow said, that if you can really get it to weigh in your favor, then you win. And in this case, he's got the fact that testimony is inconsistent. They focused on Baldwin. They stopped focusing on what was important, like the live ammunition, because they wanted to get Baldwin, and they weren't going to look at any leads that didn't lead them to Baldwin. They destroyed the evidence in the case to make sure Baldwin and his team couldn't use it. So that's the story that they're telling here with this section. Jump down to page 19 here. All right, Reeb joined the prosecution for political gain. Okay, so here's one of the special prosecutors that was appointed, and here's where some of the really ugly stuff starts. Even though Baldwin was not responsible for ensuring the safety of firearms or ammunition and was told by those who were responsible that the prop gun was safe, the district attorney decided to criminally charge Baldwin pretty close to the beginning of the investigation. To charge Baldwin with involuntary manslaughter under NMSA 1978, Section 32(3)(b), the state needed to believe that he had acted without due caution or circumspection, or that he handled or used the prop gun in a negligent manner, resulting in Helena Hutchins' death. And so here's the point. This right here, okay, this definition of involuntary manslaughter, it may end up coming down to, did the state have a good faith basis to believe Baldwin did this? Did they have enough evidence to prove that Baldwin did this? Did they go forward appropriately and prove this, even with their other mistakes? Maybe there'll be sanctions for bearing evidence, for false testimony. Maybe there was perjury. But was it all done in a concoction to get Baldwin for something that he didn't do and that they knew he didn't do? Or did they get too zealous in trying to prove a criminal committed a crime? And what do we do in those situations? Well, there is no excuse. There's nothing that will ever say it's okay to break the rules because you think you have the right guy, or else we would have that happen in so many cases with law enforcement officers and prosecutors who think that they are doing the right thing because the end result is what they consider to be justice, but breaking the rules is not justice for anybody in our country. So we have to protect against this. This is one way. If you have the power and money and wherewithal to do it and file a civil suit, there is a place for that. It can be very difficult to win. So regardless of what happens in the civil suit, this will, I believe, shine a light on a process and a bunch of different people that absolutely have wrongdoing, even if they don't rise to the level of these civil causes of action, that they deserve to be sanctioned. Some of them maybe even losing their bar license, maybe some re-education, as we've seen for some prosecutors in some other cases, maybe keep them out of the prosecutor's office in the future, potentially, maybe keep them out of political office in the future, because there should be repercussions for the actions in this case, even if it doesn't end up rising to the level of proving these civil causes of action because of all the, litigation privileges that people have and sovereign immunity and different things that protect the government in ways that normal private companies are not protected. The state also needed to believe that Baldwin's negligence, and not the negligence of another, example Halls, Gutierrez, Reed, and whoever brought the live set on set, was the significant cause of Helena Hutchins' death. And above all, even if the state did believe these things, its belief needed to be based on the actual evidence in its possession. But the evidence in the state's possession supported the opposite conclusion. And now as we get into argument, okay, lawyers that write complaints like this, you should be with them and you should be like, yes, this makes total sense. But there will be a counter argument to a lot of these. That Baldwin had exercised caution. Did he exercise caution and that even if he had not, Hutchins would still be alive if not for the superseding negligence of someone other than Baldwin, meaning whoever brought live ammo on set and whoever's supposed to check the gun, who told him to point the gun. He's pointing the finger at everybody else basically to say that regardless of what Baldwin did, it shouldn't have mattered because if everybody else did their job, this would have never happened. By June of 2022, Carmack Altweiss had privately decided to appoint Andrea Reeb as a special prosecutor to assist with the prosecution. At the time, Reeb, the former district attorney for the New Mexico's 9th Judicial District, was actively campaigning for a seat in the New Mexico House of Representatives. Reeb emailed Carmack Altweiss on June 2nd, 2022 to ensure Carmack Altweiss that she would not disclose to the media that she had been chosen as special prosecutor. At some point, though, Reeb continued, this is in an email, I'd at least like to get out there that I am assisting you, as it might help in my campaign, LOL. And here's where you start to get to the stuff that is really gross, in my opinion. This is what misconduct looks like. This is what using your position for political gain looks like. This is what happens in criminal prosecutions at times that we never find out about, that the person doesn't have to happen to be as rich or famous as Alec Baldwin to get this information and shine a light on it. So regardless of what happens in the civil case, I hope people are paying attention to what at least some of these prosecutors did in the background of this case and realize this is not the only time it happens. We talk about celebrities in the news all the time, civil cases, criminal cases. You better believe there are certain people that do the right thing, fight for justice. We followed a lot of them in trials that they've had, great prosecutors, judges, government officials, but there are some who we've also seen use their position for gain, a la Miss Becky, that absolutely are looking at this as a way to help themselves. And then when you start doing that, you start pushing the rules to the side, breaking the rules and infringing on the rights of American citizens. 4 days later, Carmack Altweiss, a Democrat, made a contribution to Reeb's Republican campaign. On August 3rd, 2022, the district attorney's office announced that Reeb would join the investigation team. Reeb immediately became a point of contact for defense counsel, as indicated that she was the primary attorney reviewing the SFSO report and handling the investigation. She interviewed witnesses, took proffers, engaged experts, and handled the important matters. On August 30th, Carmack Altweiss requested $635,000 from New Mexico's Board of Finance to pay Reeb's salary and the hiring of other personnel for the investigation, including hiring Heather Brewer as a public information officer. The district attorney's office cited the need for a dedicated public information officer to manage inquiries from the media. The state granted the district attorney's office $317,750. And we remember because we handled a lot of that together. All right. The state tried the case in the media. So we'll read kind of a chunk of this, but there's a lot more. Carmack Altweiss and Reeb, like all prosecutors in New Mexico, are bound by the ethical rules in bringing and publicly commenting on criminal cases. So lots of jurisdictions have similar rules. So we're going to read through these again to remind us these are how state attorneys, district attorneys, prosecutors are supposed to act in the media, and whether or not when we see these in other cases, are they violating the rules? Let's take a look. According to the ethical standards promulgated by the National District Attorney's Office Association, the primary responsibility of a prosecutor is to seek justice, which can only be achieved by the representation and presentation of the truth. Thus, whether full-time or part-time, the position should be approached as a career and not as a stepping stone or sideline. No matter what other activities the prosecutor is involved in, her public duties come first. Moreover, the prosecutor should refrain from making extrajudicial comments before or during the trial that promote no legitimate law enforcement purpose. So are they trying to find the guy? Are they trying to find more evidence? Are they trying to figure out who did this? Are they trying to, is there a legitimate purpose for the comments that they're making? So they should refrain from making extrajudicial comments before or during the trial that promote no legitimate law enforcement purpose and that serve solely to heighten public condemnation of the accused. They should avoid that. Think back to all the prosecutors we've seen do the exact opposite. And there's no repercussion. And there would be no repercussion in this case if that's all they did. I firmly believe that. Very rarely are they ever held to this type of standard. Similarly, prior to and during a criminal trial, the prosecutor should not make any public extrajudicial statement that has a substantial likelihood of materially prejudicing a judicial proceeding. In particular, from the commencement of a criminal investigation until the conclusion of a trial, the prosecutor should not make any public extrajudicial statement about, among other things, the character, reputation, or prior criminal conduct of a suspect, accused person, or prospective witness, the performance or results of any scientific tests, or statements concerning the credibility or anticipated testimony of prospective witnesses. And you can see here, a lot of this happened in this case. A lot of it. He says they repeatedly violated these rules. On October 26, 2021, 5 days after the accident, Carmack, by the way, they used the accident and incident a lot more than the crime, which is appropriate, started giving media interviews regarding the investigation instead of limiting such statements to those that serve a legitimate law enforcement purpose and are necessary to inform the public of the prosecutor's action. The characterizations, they began characterizing the evidence that there was an enormous amount of bullets on this set. They go into how they comment on the guilt, on how strong their case is, on how they believe they can prove it, on the FBI testing, how the trigger must have been pulled, things like that. We did an entire podcast on this. I think it was me and JD about how horribly the first go round was handled by the initial prosecutors on this case. They talked about Baldwin's high-priced lawyers. They talked about how they were going to use tactics to distract you from what's going on, his gross negligence and reckless disregard. I mean, they really went in on Baldwin and his team and discussed things about the case that those rules pretty clearly say you shouldn't do. I'll read a couple just to kind of give you an idea here about how this ended. All right. Reeb had at this point already accomplished her goal. She had won her election and assumed elected office. On March 15th, 2023, she withdrew as special prosecutor. So Reeb gets on the case, says it's going to help her campaign, talks about it in the media, how they have all this evidence. She gets elected, and then she withdraws when it starts getting ugly for them. And we'll talk about more ways it gets ugly for them. On March 29th, just a couple weeks later, Carmack Altweiss also withdraws after a hearing which the judge challenged Carmack Altweiss's ability to remain alongside any special prosecutor under the statutes of New Mexico, which allows for the appointment of a special prosecutor only when the district attorney cannot prosecute a case for ethical reasons or other good cause. Is this where, did I miss the part where they... No, we'll talk about the enhancement they did later, I think. All right, so they dismissed the charges against Baldwin. Baldwin's team, if you remember, in the media is like, good, that's justice. They shouldn't bring it again. But, of course, we know that they do. Okay, so then we start to get to more misconduct from their perspective. And one of them is Haig. If you remember, he's one of the firearm experts, and he provided a couple reports. Well, he didn't do just one, which they disclosed, or two, which they disclosed, but a third report, which the prosecutors never disclosed to the defense during the discovery time. The Haigs issued a third report. The purpose of the third report was to identify the origin of unexplained tool marks present on the working surface and sides of the evidence trigger/sear, and to determine whether they existed when the gun was on the rust set. Remarkably, the third Haig report undermined the conclusion of the Haig's earlier work. It concluded that it is unlikely that these tool marks are the result of the damage incurred during the FBI's impact testing, and that they do not appear to be original manufacturing marks or use and abuse tool marks based on their irregular orientation. Although the state promptly disclosed the first Haig report to Baldwin, the state failed to disclose Baldwin both the second, I thought they disclosed the second, and of particular concern, the third report, until months later, and months after Morrissey had obtained a grand jury indictment in which she concealed the third Haig report from the grand jury and presented it with only a select set of Haig's opinions. So this brings me to another point. They're going to talk a lot about what Morrissey did and did not present to the grand jury, and how she did present everything that was favorable to her and didn't present a lot of things that were favorable to Baldwin, and how Baldwin's team even presented her with a lot of information that she did not present to the grand jury that they believe she should have. And what I will say about this is, while parts of it may be improper, parts of it definitely may be immoral, we would hope more out of a prosecutor. These were not enough to get the indictment thrown out or get the case dismissed prior to trial. So because they did not rise to that egregious level, I do think it would be difficult for them individually to be enough to show malicious prosecution. But once again, when we start to stack up everything they've done in this case so far, and we will continue to stack pebbles on that scale. This is yet another one. Disclosing negative opinion or not disclosing negative opinions for the state, potentially exculpatory information for the defense, not providing a full picture to the grand jury, which again, this is why they say you can indict a ham sandwich, because you don't have a defense attorney there actually fighting for you. But there are rules that the defense attorney can present you information. That doesn't mean you have to present all the information the defense attorney gives you, but you should consider it and give the grand jury a full picture of this case. Oh, and another thing, during the grand jury proceedings, she tried to shorten Baldwin's time that he could respond to her inquiry for them to present some of that exculpatory evidence, which the judge denied. And again, this on its own is not something, but when you start to stack it up and show, they were trying to do everything they could to railroad Alec Baldwin. That's what Baldwin's attorneys are presenting here. He talks about the judge reprimanding the state multiple times, one of which was for telling the media info about the grand jury proceedings, including the date. And after that court appearance, they said, please do not do that again. And yet the state did it once again. They also reference a later time during the trial where they reference that throughout this process, Morrissey, who was the new special prosecutor after the prior two, withdrew from the case after they were embarrassed and they dismissed those cases. I don't know. I can't remember. It's got to be somewhere else. I'll just talk about it here in a second. But how when Morrissey said they were targeting Baldwin because he is so arrogant. Additionally, another screw up with the first set of prosecutors is they charged this enhancement, this firearm enhancement, I believe. I can't remember what it was called or what statute it is, but the enhancement was not enacted until after this incident and therefore was not supposed to be retroactively applied, meaning it was this incident happened too early for this enhancement to be applied, and they still tried to get extra leverage of a higher penalty for Baldwin to maybe get him to plea. Baldwin's lawyers are like, no way, it gets thrown out, or it was going to get thrown out, but the state withdrew it to basically save the embarrassment of getting it thrown out because everybody knew, legally speaking, it did not apply. Embarrassment after embarrassment that led to the first prosecution team to withdraw and those charges to be dismissed. But then Morrissey came in, charges Gutierrez Reed, convicts Gutierrez Reed, charges Baldwin, is ready to go forward on the trial with Baldwin, feeling very confident because she wanted to target him because he was arrogant. All right, let's jump to page 35 here for the next chunk we're going to read. Despite the trial court rulings and in violation of her duties and New Mexico law, Morrissey misled the grand jury. All right, so we talked about how this was going to be reiterated. I wanted to read at least a chunk of it. Driven by disdain and the desire to humble an arrogant prick, as she would later refer to Baldwin, Morrissey was determined to secure Baldwin's indictment at any cost. Morrissey knew, however, that if the grand jury heard all the evidence, including the documents and witnesses, the court had ordered her to make readily available. Due to their exculpatory nature, the grand jurors would see that Baldwin had not committed a crime and the grand jury would not return an indictment she wanted. Her solution was to mislead the grand jury into believing a different set of facts. She accomplished this goal by knowingly, 1, eliciting false and contradictory testimony from the state's witnesses, 2, preventing the state witnesses from saying anything favorable to Baldwin, often by cutting them off mid-sentence or redirecting them to a different topic, 3, preventing the grand jury from seeing or hearing the exculpatory documents and witnesses that the court had ordered her to make readily available to the grand jury, and 4, concealing from both Baldwin and the grand jury exculpatory opinions by the state's own experts. So some of this they're going to quibble with and argue with. Whether or not certain things were readily available. Did they ask for them? Did they know they could ask for them? How was it presented to the grand jury? Is this going to be something that on its own was misconduct, or is this, again, going to be just another pebble on the scale? I haven't read the grand jury transcript, so it's hard for me to comment on this because I know sometimes how lawyers can explain things in a way that really makes it sound like, okay, this is for sure locked and loaded, but then we get more context when we read the whole thing or hear somebody respond. So we're going to reserve judgment on this one. The state presented 7 witnesses to the grand jury. Out of those 7, 3 were paid to testify, meaning experts. 2 were officers, and 1 was and still is suing Baldwin for money. The 7th witness began publicly blaming Baldwin for Hutchins' death within days of the incident, even though he quit the production before the accident and was not on set when it occurred. Out of the state's 7 witnesses, only 1, Ross Adiego, the one suing Baldwin for money, was on set when the incident occurred. After 11 hours of being misled and lied to by Morrissey and the state's witnesses, the grand jury returned an indictment. She elicited false and contradictory testimony from each of the state witnesses. And again, whether the testimony is false and contradicted, it seems like that would be an obvious thing, right? What's true, what's false. But a lot of times there's context around testimony. So these are things that I believe will have to be parsed out in this civil lawsuit to determine, will these witnesses admit that it was false, or did they misstate something, or do they need to add context and say, no, that both are actually true? Those are things that are going to have to be proven in this case to show, is this really misconduct, or is this just criminal defense attorneys basically arguing that, because these are the same, at least one of the lawyers was the same as one of his criminal defense attorneys, as, saying, oh, that's not true, judge. But then a jury is like, no, you're wrong. And you go forward, because every case criminal lawyers are saying, oh, that's contradicting, or you can't believe this witness, or they're not credible. And sometimes juries and judges just completely disregard it, even though sometimes it feels like it does hold some weight. And again, we have to remember that none of this was enough to get the indictment thrown out prior to trial. The first prosecution was so embarrassing. Hiding the third Hague report was horrible. But what happened at the trial was absolutely horrid. Not all of these mistakes or transgressions are created equal. They discuss, I don't need to go through that as much. So then they get into something that kind of reminded me of Koberger and a lot of these other cases that we're trying, or that we're following together. Discovery violations, delayed discovery, denied discovery, motions to compel, stuff popping up so much later. Were they hiding something? Were they categorizing things wrong? There were witness statements, lapel body cam footage, text messages, conversations between law enforcement officers, all that were either hidden or delayed when Baldwin and his team specifically asked for them. They never turned them over, or they turned them over very late, all the way up until the day of trial. And we saw how all this was going on and kind of exploding even as the trial was beginning. And, every case is handled a little bit differently. Every judge looks at it a little bit differently. Defense attorneys complain about this all the time. A lot of times they are 100% correct about it, or I shouldn't say 100%. A lot of times they are some percentage correct about it. But in this case, as continued through the trial, the judge agreed with the defense and against the prosecutors, which is unusual. In Judge Summers' August 1st written order dismissing the case, the court recognized, so this was something that came into her head when she ended up dismissing the case at the end of the day, which was for another discovery violation, which again, this is also an example of why it's so important to protect the record and document the record every time whoever your opponent is screws up, breaks the rules. By the way, you got to make sure you're following the rules. But every time they do this, every time they delay it, same thing in Koberger's cases, same thing we saw in a lot of different cases. They're violating discovery. Karen Reed's case, we're seeing it in as well. You're not turning stuff over. You're turning it over late. You're not giving us enough time to respond. You're giving us big bulks. We can't find what it is. You always document that, because you never know what will be the straw that breaks the camel's back in the judge's mind. But in the judge's written order, she recognized that the state continually made late disclosures to the defendant throughout the pretrial litigation, which they complain about in this complaint. And even in the days immediately preceding the jury trial beginning on July 9th, 2024, the court noted that these violations continued, despite the fact that on July 1st, 2024, the state filed a certificate of compliance in which Special Prosecutor Morrissey stated that she had transmitted to counsel for defendant, pursuant to the provisions of Rule 5501, all materials and documents in her possession enumerated in the provisions of Rule 5501 for disclosure by the state. The court further noted that the state's representations weeks before trial that it had conducted a complete audit of its discovery disclosure files as soon as it was aware that potential problems existed, and has cured any discovery disclosure issues. Simply put, Morrissey had intentionally deprived Baldwin of evidence that was required to be disclosed under New Mexico law and the U.S. Constitution, and she had repeatedly lied to Baldwin in the court about the state's compliance. Not good. Not good. And again, they talk about how Morrissey made some arguments that he was a producer. She abandoned those arguments, then tried to do it again for that's prosecutorial misconduct. And, defense lawyers, I would argue, think prosecutorial misconduct happens a lot more than it does. I also think they make the argument a lot to make sure that the judge is watching, that the prosecutor's bosses are watching, that the people are watching. It's like, come on. Let's play fair here. We got the YSL trial. We got the YNW Melly trial. We got this trial. We got all sorts of trials where this stuff, the Karen Reed trial, Koberger trial, where allegations of prosecutorial misconduct happen and they occur. I bet we're going to get it in the Diddy case. Because when you have a big fish, those allegations will come, and some of them are a lot stronger than others. The dismissal of the producer theory left more. Okay, so this is important. Before we get to the cause of action, a lot of people were asking, why is this ammo piece? Why is it so important? Why did the judge dismiss the case over it? It doesn't seem like it was that big of a deal, et cetera, et cetera. Well, Baldwin's team has a theory, and they say because the judge dismissed the producer theory, that left Morrissey's case hanging by a thread. She therefore sought to connect Baldwin's state of mind to the cause of Hutchins' death, i.e., the existence of live ammunition on set, by claiming that Gutierrez Reed was the source of the live ammunition, showing Gutierrez Reed's age and supposed inexperience, and arguing that Baldwin was therefore aware of the risk that she might bring live ammunition on set. So that's how they're connecting how important it would have been to have this other discovery of the additional ammo to compare, contrast, and discuss. Now, I believe I remember the state making some different and additional arguments to this, so I'm not so sure they're going to agree that this was all they had left or that their case was hanging by a thread. I also think there are a lot of people in the chat that follow the channel, that follow the case, that thought Baldwin was going to end up getting convicted at the end of the day. And that's possible, but if you have the misconduct you had in this case, it was absolutely in the interest of justice to dismiss this case, and I still stand by the fact that the judge did the absolute right thing. And I absolutely believe that the prosecutors committed I don't know if malpractice or misconduct throughout this process. Was it enough to win a civil lawsuit? Let's get to the causes of action here. I jumped past the first one. The trial revealed the shocking depths of the state's bad faith and scorching prejudice, and that's when they didn't put the right name on certain evidence that came in. Seemed like they buried it. There were these interviews and lapel camera footage that nobody ever saw. There were law enforcement officers that didn't even talk about conversations that happened. It's tough to say they did anything else but lie to say that that stuff didn't happen, and that's why the case ended up getting thrown out. Motions in limine were to be argued on July 8th. Jury selection was to begin on July 9th, and the first day of trial was scheduled for July 10th. By the time of the motion in limine hearing, Morrissey made clear that she intended to argue that Baldwin was criminally liable for Hutchins' death because he was a producer of the film, even though she had previously dismissed the theory as lacking merit. I already went through this. We don't need to read it again. All right, I'm just going to pick up here on paragraph 234. Evidence that tended to show that Gutierrez Reed was not the source of the live ammunition, evidence that the ammunition came from an outside source, would have undermined Morrissey's key basis for linking Baldwin to Hutchins' death. When that evidence emerged, Morrissey decided to bury it. By at least November 1st, 2021, the state was aware that a man named Troy Teskey, a retired police officer in Bullhead City, Arizona, had a cache of ammunition that could have been the source of the live round that ultimately made its way onto Rust. Rather than investigate this lead independently, Detective Hancock simply accepted a screenshot of a photograph of only 4 bullets that Teskey had sent to Kenny. The sample included Starline brass bullets, though they had brass primers, not nickel. However, Kenny explained at the time that the manufacturer may have mixed primers when preparing the reloads. Detective Hancock agreed, noting that testing at least a few of the rounds would be really important. Kenny told Teskey that the ammunition was evidence in the accidental death investigation. Teskey hand-delivered the ammunition to SFSO on March 6, 2024. He entrusted it in the care of Popple, the crime scene technician who had worked on the Rust case from the first day, who knew Kenny. She also knew of Joe Swanson, the manufacturer. Among the rounds Teskey provided were Starline brass casings with nickel primers, rounds that had matched the live round that killed Hutchins, but had never been collected, analyzed, or provided to the defense. Once received, the evidence was not inventoried to the Rust case. Instead, after a discussion between Popple, Detective Hancock, their Lieutenant Brian Brandel, and Special Prosecutor Morrissey, the ammunition was logged under a separate case number. Perhaps these are the most damning things that anybody did, basically to bury this stuff. And this is the reason the case was ultimately dismissed. And this is how we knew that this civil lawsuit was coming. The decision to misfile the evidence was made deliberately and jointly between members of law enforcement and Morrissey. The state never disclosed this ammunition to the defense, never disclosed the supplemental report recounting the importance and details about this evidence, never provided the ammunition during the evidence viewing, and falsely certified that the state had disclosed all relevant evidence before trial. The state's primary justification for withholding the evidence, that there was no indication it matched the live ammunition on set or that it was unclear whether it was really tied to Rust, was belly not only by the physical evidence itself, but by the SFSO's own report. Yet Popple initially testified to the opposite when Morrissey knowingly elicited false testimony from her that the rounds did not match that from on set. And let me ask you, Ms. Popple, the ammunition that the Good Samaritan, Mr. Teskey, the close friend of Hannah Gutierrez's dad, when that ammunition that he brought to you after her conviction, you still have it? Yes. You can bring it here and we can show it to the jury, right? Yes. And they can see for themselves that it does not match the live ammunition from the set of Rust, correct? Yes. And that it is obvious just when you look at it, is it not? Yes. That false testimony was rebutted the next day. As Judge Summer explained, Corporal Hancock testified that CST Popple gave false testimony during the second day of the trial. Specifically, Corporal Hancock testified that CST Popple's testimony given in front of the jury concerning the attributes of the collected Teskey supplied ammunition when compared to the attributes of the live ammunition collected on the set of Rust was false. And again, some they'll be able to argue. Is that false? Is it true? I don't know. Others, the judge seemingly, has decided that was, in fact, false. The state's cover-up crumbled at trial. The state knew that these rounds matched. The 3 matching rounds were the first ones logged in the hidden report, described as having the 3 key features matching the live rounds from Rust: 45 caliber, Starline brass, silver primer. When Judge Summer questioned Popple the next day, she was forced to admit as much. Judge Summer, all right, let me ask it to you a different way. Do you recognize any of these types of bullets to have been gathered on the Hannah Gutierrez on the Rust set? The witness, the Starline brass with the silver primer are similar to what was collected on set. There was no doubt that Teskey, a witness known to SFSO from the Rust investigation, had made clear that the evidence he was providing to them was from the same batch of ammunition as the round that killed Hutchins. And this undisclosed SFSO report stated, Mr. Teskey informed CST Popple that he had live rounds of ammunition that he believed to be connected to the Rust case. Mr. Teskey stated that he had ammunition that he believed from the same batch of ammunition that was located at Seth Kenney's warehouse in Albuquerque. Mr. Teskey informed CST Popple that he had informed Detective Hancock and Seth Kenney about the live rounds on November 5th, 2021 via phone. Mr. Teskey stated that these rounds originated from Joe Swanson and he was asked to bring them to court by the defense. The defense, in turn, did not call Mr. Teskey to the stand, and Mr. Teskey no longer wishes to keep the ammunition. The defense they're talking about there is Hannah Gutierrez Reed's defense. Even in light of these explicit and detailed explanations, the state still tried to cover its tracks. It argued first that the evidence had been logged separately because it was not collected at the set. Then it argued that this occurred because the evidence was not collected by SFSO officers independently. And finally, the state claimed it was not logged to the Rust case because Teskey had supposedly not returned the state's phone calls. Notwithstanding his repeated offers to give a statement when he provided the ammunition and his detailed account of its origin that were captured on an SFSO lapel video played at trial. Morrissey doubled down. She offered increasingly inconsistent explanations for the failure to disclose the existence of the ammunition to Baldwin. For example, she initially argued that the rounds would have been relevant if they had matched the rounds on Rust. But then she argued that they could not have been relevant unless they had been shown to have left the state of Arizona. Morrissey further tried to minimize and sanitize the state's actions, attempting to justify the state's failure to allow the defense to view the ammunition by saying, I had never seen it and I didn't realize that it wasn't under the same case number because I'm not a law enforcement officer. I don't work at the sheriff's department. However, as the court noted, this testimony conflicts that of Corporal Hancock, who testified SFSO agents and Prosecutor Morrissey decided to separately file this evidence apart from the evidence of the Rust investigation. Ouch. And this is the type of stuff that needs to be dealt with one way or the other, whether it's this civil suit or otherwise, but this needs to be dealt with. There can be no doubt as to what happened here. The state first deliberately ignored this exculpatory evidence and then, when able to ignore it, further buried the exculpatory evidence. The state never disclosed this evidence to Baldwin, notwithstanding the repeated discovery demands, evidence viewings, and representations by the state that it had complied with its obligations. After extensive testimony from Detective Hancock, Popple, Brandel, and Morrissey herself, the court concluded as follows. The state's willful withholding of the information was intentional and deliberate. If this misconduct does not rise to the level of bad faith, it certainly comes so near to bad faith as shows signs of scorching prejudice. And that quote is the best piece of evidence to roll into this civil complaint. The court further concluded, given the state's egregious discovery violations constituting misconduct and false testimony elicited during trial, dismissal with prejudice is the appropriate remedy. A result of the defendant's unlawful conduct, Baldwin has lost significant compensation and suffered significant damages. So we know it was enough to dismiss the criminal case. Should be enough for some kind of sanction or some kind of remedy where the state has to either take courses, have to retake the bar, something, some kind of repercussion for the state's action in this case. But is it enough to win these civil claims against a prosecutor? Well, now we are going to get to the causes of action. The first cause of action is for violation of rights under 42 USC Section 1983, conspiracy to cause malicious prosecution and deprivation of civil rights. Defendants, while acting under the color of law, conspired to procure a groundless indictment against Baldwin and to maliciously bring about or advance Baldwin's trial and conviction, thus violating Baldwin's constitutional right by their improper use of the criminal process. So this is the big question I have for you guys in the chat. Let me know what you think. Was this a groundless indictment? Did they have no actual evidence? This is a case where evidence is planted usually, or you get a witness to say something or lie because you want them to point out the wrong person because you want to get that person. That's usually what this is reserved for. But in this case, all of the egregious errors, mistakes, discovery violations, buried evidence, take all that out, right? As bad as that is, did they have evidence in a good faith basis to believe that they could prove that Alec Baldwin committed a crime? The real evidence, not the buried evidence, not the false testimony, not the contradicting testimony, even if we're going to take it that way for the prosecution, but what they actually did have, was it enough? Defendant's conduct included, but was not limited to, the following acts. Altweiss, Macias, and other members of FJDA directed law enforcement to deprioritize the investigation into the source of live ammunition on the Rust set and into the key suspects related to that inquiry, and to focus instead on obtaining witness statements and evidence that prosecutors could use to manufacture probable cause to charge Baldwin with the crime. Is that true? Is it true that two things can't be true, that Baldwin could have committed a crime and Hannah Gutierrez Reed and maybe Seth Kenney and David Halls? While the explicit motive of disproving what Baldwin said during a televised ABC News interview, i.e. that he did not pull the trigger, Hancock and Popple requested, ordered, and approved destructive testing on the firearm without documenting the firearm's internal components before its destruction, knowing that it would prevent Baldwin from examining the state of the firearm as it existed on the day of the incident. So number one, I agree they should not have done destructive testing. I agree they should have gotten maybe some defense expert there, done everything they could to preserve it. But where I disagree with them is whether or not Baldwin said that, they should do this testing to determine, did the gun go off on its own or was the trigger pulled? That's an important aspect of this case. Defendants Altweiss and Reeb charged Baldwin with a firearm enhancement that was legally barred under the ex post facto clause of the United States Constitution, and for which there could be no probable cause. I agree with that. That was very dumb and does not look good, especially in light of the rest of the allegations. Because of one, defendant Reeb's simultaneous role in the state legislature, and two, defendant Carmack Altweiss's statutory inability to prosecute Baldwin alongside a special prosecutor under 36.123, defendants Carmack, Altweiss, and Reeb lacked constitutional and statutory authority to charge Baldwin with any offense. That's minimized by the fact that they dismissed it and then it was brought again. But again, just from their perspective, was that malicious prosecution that they should have never even been able to charge him based on this, and definitely should have never been able to charge him with an enhancement. Now, I will also say, unfortunately, it does happen when prosecutors charge defendants with statutes that are improper, that are either the statute of limitations or that they can't charge retroactively, meaning the law came into effect after the crime and they try to charge it to a crime in the past, and that's improper in most cases. It doesn't automatically mean malicious prosecution, but it's not good. Altweiss appointed Morrissey as special prosecutor with the understanding that she would advance Baldwin's malicious prosecution and continued to contribute FJDA resources to Baldwin's prosecution. At the request of Morrissey and in furtherance of Morrissey's malicious objectives, Hancock presented false, distorted, misleading, and perjurious testimony to the grand jury to procure a criminal indictment in the absence of probable cause. Defendant Morrissey knowingly failed to disclose exculpatory information that she had received from the state's experts to deprive the grand jury of information that undermined the case against Baldwin, or in the alternative, administered policies and practices with respect to the disclosure of evidence that she knew were inadequate to fulfill her constitutional duties to Baldwin. Defendants Morrissey, Hancock, Popple, and Brandel, on the basis of information and belief, defendant Altweiss intentionally caused or agreed to cause exculpatory evidence not to be inventoried to the Rust case file, but instead to be inventoried by creating a new case number and inventorying the evidence to that new case number and failed to disclose that evidence to Baldwin or to make it available for his inspection, despite knowing the evidence was related to the Rust case and in his defense of the charges against him. So again, this is what I like when they pull these specific evidence and facts that they believe proves the cause of action, because it gives us the opportunity to see, is there enough here? What needs to be proven to get across this bar? Each of the overt acts described above was made in furtherance of defendant's conspiracy to deprive Baldwin of his civil rights, and throughout the acts described above, defendants acted in concert pursuant to an agreement, meeting of the minds, or general conspiratorial objective. In carrying out their conspiracy, defendants were driven by ill motives to accomplish illegitimate ends, including harass or humble Baldwin to promote their political agendas in the case of Altweiss and Reeb, or to further their own personal agendas or professional ambitions. Altweiss, Reed, Paget, Macias, Morrissey, Hancock, Popple, Brandel. The defendant's actions violated the constitutional rights guaranteed to Baldwin by the 14th Amendment of the U.S. Constitution and or the laws of the United States. The immunity typically afforded to the prosecutors acting in their quasi-judicial role does not apply to the above actions undertaken by the defendants Carmack, Altweiss, Reeb, and Paget, Macias, including because they were performed in an administrative or investigative capacity beyond the prosecutorial function before any determination of probable cause was made, outside of any statutory authority or judicial reform pursuant to an invalid appointment. The immunity typically afforded to prosecutors for acting in their quasi-judicial role does not apply to the above actions undertaken by Morrissey, including because they were performed in an administrative or investigative capacity beyond the prosecutorial function, outside of any statutory authority or judicial reform, and or in connection with factual testimony given by Morrissey. So this is going to be a big part of this discussion as well. Where does the immunity apply? Where does it not? Defendants' actions were not undertaken in good faith and were in violation of clearly established law. Defendants' actions were unnecessary, unreasonable, unlawful, and unjustified. On July 31st, 24, the trial court dismissed with prejudice all charges against Baldwin on the grounds that the defendant's egregious discovery violations, suppressed evidence, and false testimony deprived Baldwin of his constitutional right to a fair trial. We knew that the judge was going to be quoted in this lawsuit. I think I even mentioned as such during that fateful day where everything exploded in court, which we also have a full video on if you guys want to go check out all of what happened in real time to end this trial in explosive fashion. The grounds for the trial court's dismissal of the charges against Baldwin are indicative of Baldwin's innocence. As a direct and proximate result of the defendant's unreasonable and unlawful actions, Baldwin has suffered and continues to suffer substantial past and future damages, both compensatory and general, including but not limited to legal expenses, loss of income, severe emotional stress, mental anguish, and embarrassment in an amount to be determined at trial. Because defendants' actions were motivated by evil motive or intent and involved a reckless or callous indifference to Baldwin's federally protected rights, an award of punitive damages is appropriate to the fullest extent permitted by law. Okay. Next is the violation of civil rights, suppression of evidence, and deprivation of civil rights against Hancock, Popple, and Brandel, the law enforcement officers. This specifically has to do with they inventoried the file under a new case number, not under the Rust file. They violated his constitutional rights. The actions were not undertaken in good faith. They were unnecessary, unreasonable, unlawful, unjustified, and he suffered damages. Third cause of action, malicious abuse of power against Hancock, Popple, Brandel, and the county. All right, so here's what they did. Conduct that includes but is not limited to the deprioritization of the investigation into the source of live ammunition. Okay, we already read that. With the explicit motive of disproving what Baldwin said in a TV televised interview, presented false evidence, intentionally caused exculpatory evidence to be filed under a different case. So again, similar facts, different cause of action, different defendants. Under section 41412 NMSA, the immunity granted under that section does not apply to liability for personal injury resulting from malicious abuse of process or the deprivation of any rights, privileges, or immunities secured by the Constitution and laws of the United States or New Mexico when caused by law enforcement officers while acting within the scope of their duties. So here's another section. They're going to have to disprove this immunity that is sovereign immunity that protects law enforcement officers, around the country and in New Mexico. And they're going to have to prove specifically, this is how they get around it, that it was liability for personal injury resulting from malicious abuse of process or the deprivation of any rights, privileges, or immunities. So it wasn't an accident. It wasn't something that they thought the prosecutor was still going to get this file and it slipped through the cracks. It wasn't something they forgot. It has to be liability for personal injury resulting from malicious abuse of process. Intentional spoliation of evidence. Again, Hancock, Popple, commissioners, and the county. All right. They tried to disprove what he said on the interview. Hancock and Popple knew that performing the destructive testing and failing to document the internal components of the firearm would prevent Baldwin from examining the state of the firearm as it existed on the day of the incident. So they weren't the ones that performed the destructive testing. So I'm not so sure Baldwin's going to be able to prove that they knew that this was going to be destructive testing or that something was going to happen to not keep the evidence in an examining fashion. The destructive testing and defendant's failure to document the internal components did, in fact, prevent Baldwin from examining the firearm as it existed on the day of the incident, undermining his ability to prove his theory. Again, they think they can get around this immunity because this is liability for personal injury resulting from intentional spoliation of evidence or the deprivation of any rights, privileges, or immunities secured by the Constitution or Mexico when caused by law enforcement officers while acting in the scope of their duties. And they suffer damages. Defamation per se against Carmack, Altweiss, and Reeb. And again, this is not going to be in the documents, in the indictment, and any of the filings, because that'll mostly be covered. But their media statements. Altweiss and Reeb made false and defamatory statements of fact concerning Baldwin, and to the extent of any of their statements can be considered media matters of opinion. Such statements implied the existence of defamatory facts as described below. So in most situations with a litigation privilege, it can be certain media discussion around the case can be covered by it, certain can't. On January 19, 2023, defendant Altweiss appeared on CNN to discuss key pieces of evidence with a reporter from the Santa Fe New Mexican. During the program, Carmack Altweiss asserted that Baldwin had a duty to make sure the set was safe and he should have checked that gun, checked those projectiles, falsely implying that Baldwin was responsible for Elena Hutchins' death. Okay, so did he have this duty? Should he have checked the gun? Those are still open-ended questions that have not been decided. So Baldwin's team is stating them as fact, like she lied, but we still have to make those determinations. There's a difference between lying and saying something you know is false and being wrong or misunderstanding something or trying to prove something and a jury didn't take it your way. On January 1923, Altweiss and Reeb appeared on Janine Pirro's program on Fox News, stating that it was not a safe set and asserting that it was Baldwin's responsibility to ensure the set's safety. Again, falsely implying that Baldwin was responsible for Helena Hutchins' death. Defendant Carmack Altweiss also falsely accused Baldwin of deleting information from his phone, which she knew was false at the time. They're going to have to prove she knew that was false at the time. It's easy to say. In the same interview, Reeb stated that a lab report confirmed that definitely the trigger was pulled. And again, if you go back to the very beginning when we read what prosecutors are not supposed to do in the media, talk about the results of testing, while omitting that the same lab report referred to the testing in which the FBI broke the firearm at issue by hitting it repeatedly with a rawhide mallet without first inspecting or documenting the condition of the firearm. Do they have to do that in the media? Do they have to qualify it with those comments? No is the answer. Thereby preventing Baldwin from inspecting the condition of the firearm when it discharged or conducting any of its own testing. So if it was an appropriate statement, they don't need to give the qualification. It was like, oh, and we destroyed it during testing, if in fact it was true that the trigger was pulled. Now, they shouldn't have done it according to the rules, the ethical rules of what prosecutors are supposed to do and say in the media. Defendant Reeb also omitted the informal testing that defendant Carmack Altweiss had conducted in February of 22, which demonstrated that Baldwin's claim not to have pulled the trigger was plausible. In an interview with NBC News on January 19th, Reeb commented on Baldwin's ultimate guilt, stating that he is somebody who committed a crime. Again, totally inappropriate. Defendant Altweiss repeated factual conclusions about the evidence that we know from the FBI lab report that he pulled the trigger. These national media appearances, defendant Altweiss and Reeb repeatedly stated that Baldwin was facing many years in prison, even though if convicted, the maximum sentence was 18 months, implying greater criminal culpability and more severe criminal act on Baldwin's part. Yeah, because they unfortunately were dead wrong about the enhancement, which I think added 5 years, which is like, ugh. The day before charging Baldwin with 2 alternative felony counts of involuntary manslaughter, the defendant Carmack Altweiss office posted on Facebook, the evidence and the facts speak for themselves. February 7th, immediately after Baldwin filed a motion to disqualify Reeb because her appointment violated the separation of powers principles, a spokesman for the defendant, Carmack, Altwise, and Reeb, told news media that Baldwin and his lawyers can use whatever tactics they want to distract from the fact that Helena Hutchins died because of gross negligence and the reckless disregard of safety on the Rust film set. These statements made in connection with Baldwin's legal filing carried the unmistakable implication that Helena Hutchins died because of Baldwin's criminal negligence. That's why it's like, to go after, say, oh, these high-priced lawyers, or, these lawyers will say anything for their clients, not a good move and can come back to bite you. These statements made, now, if they say something that's completely wrong or false, point it out, of course. If they do something inappropriate, point it out, of course. But if they just take proper legal action that ends up being completely right because you dismissed the enhancement and you both withdrew from the case, this really comes back looking terrible. And we took a whole hour just breaking that mess down. On February 10th, immediately after Baldwin filed a motion regarding an unconstitutional charge that was filed against him, a spokesperson for the defendant, Always, and Reeb, issued the following statement to the media. Another day, another motion from Alec Baldwin and his attorneys in an attempt to distract from the gross negligence and complete disregard for safety on the Rust film set that led to Helena Hutchins' death. And again, this same Baldwin attorney, which was Alex Spiro, is having a very similar fight with Tony Busby in the Jay-Z, P. Diddy situation. But again, just because lawyers are filing motions does not mean they're doing something wrong. It can be, depending on the language of the motion, what you're asking for, what you're doing, what you're saying, and how a judge reads it. That's usually the ultimate importance. But just being a high-priced attorney, a successful attorney who does a very good job, should not be held against you in the media or with the judges in responses to your legally appropriate motions that do end up being the winning motion, the successful motion in a case like this one. Reeb would remain focused on justice and ensuring that everyone, even celebrities with fancy attorneys, is held accountable under the law. It's just gross now to read this stuff. It was gross back then, but it's even worse now. These statements, made in connection with Baldwin's legal filings, carry the unmistakable implication that Hutchins died because of Baldwin's criminal negligence. Now, what I will say is, like the judge in the federal case that Spiro's handling with Jay-Z right now, if she has specific issues with what you say and how you say it, calling people out, saying things that are irrelevant, trying to use the media, trying to do things to bully another lawyer, fine, call it out. But what they did in this case, which was point out a lot of problems with the prosecution and rules being violated that the judge ended up agreeing with, you can see how it looks so different depending on what a lawyer does, even if it's the same lawyer in two different cases. Every case is different. February 20, 2023, after conceding that they had erroneously charged Baldwin with a sentencing enhancement that violated the ex post facto clause of the United States Constitution, defendants Carmack and Altwise and Reeb made a public announcement. If my dad was on, he would give a great explanation of the ex post facto clause of the United States Constitution, I'm sure. But basically, it's supposed to protect you from doing something today like streaming on YouTube. And then let's say our government in a month says it's illegal and you can go to prison forever if you stream on YouTube, for coming back and prosecuting me for something that was completely legal at the time that I had no idea was going to be illegal 5 years from now. And now that it's illegal, you can't reach back and convict me for something that at the time was not a crime and I never knew it could even potentially ever become a crime. Instead of acknowledging the impropriety of what they had done or that they had filed an unconstitutional charge, they stated that they were withdrawing the enhancement to avoid further litigious distractions by Baldwin and his attorneys, aka they were going to lose and they knew it. The district attorney's office told the media that the prosecution's priority is securing justice, not securing billable hours for big city attorneys. Guess what? Hey, you know how you can make them make even less money and no billable hours? Drop all the charges. They'd be happy with that. Everybody'd be happy with that. Like, to say you're making prosecutorial decisions based on another attorney's billable hours, again, oof, gross. These statements carried the unmistakable implication that the sentencing enhancement, which carried a mandatory minimum sentence of 5 years in prison, had been properly filed against Baldwin, even though defendant Reeb had privately conceded to Baldwin's attorneys that she 100% agreed that charging the firearm enhancement violated Baldwin's rights under the ex post facto clause of the United States Constitution. So privately, she's agreeing with Baldwin's attorneys, being like, yeah, you're 100% right. We're going to, pull that enhancement. We can't retroactively do that. But then publicly being like, we're just going to withdraw this because we don't want to fight about it anymore and litigate it right now. It's not important. And we don't want them to just make money as big city lawyers with billable hours. On March 14, 2023, defendant Reeb announced that she was stepping down as special prosecutor, but rather than acknowledge her appointment had violated the U.S. Constitution's guarantee of separation of powers, Reeb issued a public statement that the best way I can ensure justice is served in this case is to step down so that the prosecution can focus on the evidence and the facts, which clearly show a complete disregard for basic safety protocols led to the death of Helena Hutchins. These statements made in connection with Baldwin's case carry the unmistakable implication that Hutchins died because of Baldwin's criminal misconduct. Now, another thing that's going to have to be determined here is, was Baldwin factually innocent? So every time they said he was negligent, or every time they said his actions led to Hutchins' death, is that a lie? Is that defamation? Or is it true? Or is it at least an opinion held in good faith basis based on the evidence and the facts that they know and saw? The fact that, this bullet from Teskey was buried, does that mean that now the prosecutors, now that everybody knows about it, they were like, yeah, we knew it wasn't Baldwin? None of them are going to say that. They're going to all say that evidence didn't matter one bit. A lot of you guys have that same sentiment, and I get it. Would it have mattered? Could it have mattered? Maybe, maybe not. But generally speaking, you just can't do that. And when you do that as a prosecutor, you pull those questions off the table. You literally make it doesn't matter whether he did it or not, because you so egregiously violated his rights. And when you do that, he must walk. So don't do that. That's what we need to tell prosecutors. Because when they do that, everybody loses. Baldwin's now been accused of something. It has absolutely affected his life. Helena Hutchins and her family has to sit over there and wonder, did they not get justice because you guys screwed it up? There's all this misconduct allegations thrown out. We got prosecutors stepping down. We got legal careers being affected. We've got ethics committees probably making decisions, and we've got civil lawsuits now. But these questions are far from answered. The above statements were false when made. Were they? That's up for debate. And defendants Carmack, Altweiss, and Reeb made them knowing that they were false or with reckless disregard as to their truth or falsity. The facts and defamatory statements carry the unmistakable message that Baldwin committed a serious crime, that he negligently or recklessly caused the death of another human. The false and defamatory statement also relate to Baldwin's trade or profession because they carry the unmistakable implication that Baldwin disregards safety protocols on film sets and was grossly negligent to a criminal degree. Based on the foregoing, the false and defamatory statements above constitute a defamation per se. If they were not defamatory per se, they were defamatory per quad. The immunity typically afforded to prosecutors acting in their quasi-judicial role does not apply to the above actions and statements made by defendants Carmack, Altweiss, and Reeb to the news media because they were made beyond the scope of their statutory authority and prosecutorial function and outside of any judicial forum. I think this is also going to be up for debate, paragraph 294. But that's why we have the court of law. As a direct and proximate result of the false and defamatory statements above, Baldwin had suffered and continues to suffer substantial past and future damages, both compensatory and general, including but not limited to legal expenses of loss of income, severe emotional distress, mental anguish, and embarrassment. 6, cause of action. For violation of Civil Rights Act, deprivation of civil rights in violation of NM Constitutional Article 2, Section 4, 18, and 19 against FJDA commissioners and the county. Okay, so how did they violate these? The conduct that it was included but not limited to. A, with the explicit motive of disproving that Baldwin said during the interview, okay, he was charged with enhancement that was legally barred. At the request of Morrissey, presented false, distorted, misleading evidence and testimony, failed to disclose exculpatory evidence, and they filed it under a separate case file. Each of the overt acts above was made in furtherance of the defendant's conspiracy to deprive Baldwin of his civil rights, and throughout the acts described above, defendants acted in concert pursuant to an agreement, meeting of the minds, or general conspiratorial objective. In carrying out their conspiracy, defendants were driven by ill will. Okay, we read all this. How they're going to get around the immunity. It does not apply to liability for the deprivation of any rights, privileges, or immunities secured pursuant to the Bill of Rights of the Constitution of New Mexico caused by a public body or person acting on behalf of, under color of, or within the course and scope of the authority of a public body. The immunity afforded to prosecutors. Okay, talk about that. Egregious discovery violations. Again, more quotes from the court. All right, so a lot of repetition there. His prayer for relief, and he demands a trial by jury. Luke Nikas. I think it's Nikas. Yeah, definitely not Nicholas because there's no L. Proac Vice coming in. Oh, there is Spyro. My bad. I didn't see Spyro before. I'm sure a bunch of you are going to be letting me know that off the top. So maybe Spyro is still involved. I would expect him to be. Okay. So I will say we have successfully handled a case similar to this, where we sued a company who gave information about our client that led to her getting arrested, thrown in jail, kept in there for a while, prosecuted criminally before the charges were eventually dismissed. And we ended up proving to law enforcement and the prosecutor's office that this information was false and knowingly false. When information was given for the initial arrest affidavit to the cop, we think he should have easily done an investigation to find out that it was false and didn't. But we were only successful and collected a pretty good settlement amount from the company whose employees gave the false information to get our client arrested, not from the prosecutors, not from law enforcement. And we worked well with them to get the charge dismissed, which was the most important. But our client even went to jail for multiple days. So those damages, you could imagine, are incredibly severe. And when people give false information, it was a white collar crime dealing with money. And it was just absolutely horrible how completely incorrect this information was. And it led to our client's arrest. And like I said, there's a lot of immunity and privileges that you have to deal with because we want people are protected to report crimes, right? We want to protect victims. And the person that lost the money here, or believe they lost the money, is a victim who deserves justice. And if our client did that, they deserve that justice with that conviction. But when somebody's wrongfully accused and gets the initial punishments that a presumed innocent person gets in our country, serious damages ensue. So it is very difficult to win these cases against prosecutors, but it does happen. And this case has a lot of publicity, which is helpful for Baldwin. Baldwin has a large platform, which is helpful in this case, to where I think they will be successful in procuring some kind of settlement. Although if this was just your everyday person, I still think this would be a difficult case to win. But whatever way the prosecutors and law enforcement involved in this investigation and prosecution, whatever way they get reprimanded, I'm okay with, to all extent of the law, because what they did was wrong. It was horrible. They violated his constitutional rights. They called into question everybody that they investigate and charge in their jurisdiction. That are they going to stay within the lines of what's appropriate and legal, or are they going to break all the rules because they think they know better and they think they've got the person that's committed a crime? And we just can't have prosecutors and law enforcement officers doing those things. So thank you guys for joining me. If you enjoyed it, please hit that like button and make sure you subscribe to our page. That's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.